morning, everybody.
Good morning, Your Lordship.
Good morning.
Yes. Good morning.
Good morning, Lordship.
List करिए.
Under the heading for orders, withdrawal of case. Item 1, WPT number 3483 of 2021, Mr. Prasant Verma for the petitioner, Mr. Rahul Amar, Rita Sinha.
If it may please the court, my lord, I am appearing on behalf of the petitioner in item number 1 as well as in item number 2. My lord,
Similar order like
yes, sir. My lord.
कल सुनिए जितेंद्र, कल के लिस्ट में जो पिटिशनर रिज्यूम कमर्शियल का जो ऑर्डर हुआ था वही ऑर्डर इसमें भी कर दीजिएगा. पैरा 1 को रिकॉर्ड कर देना है, प्रेयर वगैरह सेम, सिर्फ पैरा 1 रिकॉर्ड कर दीजिए. दिस लिस्ट हैज विथड्रॉन.
Oblige, my lord.
अदर साइड मिस रीता.
WPT number 3494 of 2021.
Lordship, सीरियल नंबर 2 FS 7217 में हम अपीयर कर रहे थे हुजूर.
सीरियल रेगुलर लिस्ट कॉल होने दीजिए.
Under the heading for orders will effect item 1, first appeal number 18 of 2021, Mr. Somitra Babu for the list of the.
This is that amicus that matter, Mr. Sinha.
Yes, maintainability of it.
It defects में क्यों चल रहा है? अच्छा, maintainability. So any other day, Mr. Sinha?
Very well, minutes. Whatever is convenient to your lordship.
Correct. अपडेटेड है ना ये लिस्ट आपका तिवारी जी? लिस्ट अपडेटेड है ना? तो फिर कीप इट ऑन either next Thursday or next to next Thursday.
That means Thursday. Your lordship is saying Thursday. 17 to 24.
17, yes.
Very well, minutes. Any day. 24th is.
Brother would be hearing it for the first time, so you will have to argue all that.
Yes, I have not found out. My colleague has found out 2 foreign old case laws, but not in Michigan law review, which also supports your lordship's view. But this is not directly on the point, but they say that maintenance pendency right is an interlocutory order. There is a reference of these. I'll send those also.
Okay. Please send. So appearance record कर दीजिए councils का. Mr. Somitra Baroy, are you appearing?
Yes, my lord.
Come on the screen.
Yes, my lord.
Mr. Amicus Curiel, Mr. Indrajit Sinha. Mr. Astosh Anand, you were supposed to be appearing to assist the court after you have withdrawn your own first appeal.
I'll tell him. He may not have noted it, but I'll tell him.
Mr. Sinha, you tell him.
Yes, I'll tell him.
Whatever assistance he wants.
Yes, surely.
24th, as prayed for by the Council for the Practice, list the case on 24th February 2000 Thursday, 22 Thursday. He would be supplying certain more decisions, few more decisions on the issue.
Right.
For the next.
Great.
Next Thursday we will do it.
Next Thursday or next to next?
Sorry, next to next Thursday.
Yes.
Yes.
2 for orders. First appeal number 72 of 2020, Mr. Ashok Kumar Sinha, number 4 for the appellant, Mr. Arvind Kumar for the response.
I am appearing, Lordship. in item number 2, FS 7217, Lordship.
Some affidavit regarding cost was to be filed.
Lordship, but at the last chance given, Lordship, I will take instruction, file or not, but of debit has been not filed, Lordship. So if he will deposit, then immediately I will file, Lordship.
Mr.
As a last chance may be given.
Counsel for the appellant speaks and is allowed 2 weeks by way of last indulgence to comply the order relating to payment of cost and file an affidavit to that effect.
Item number 3, first appeal number 234 of 2017, Mr. Jiten Nandupalia for the appeal.
For this case, I am appealing for the appellant. The case has been admitted and called for LCR and IA filed for early hearing.
So 2017 matters are being taken up. The moment hearing matters are listed, your appeal should come up. IA number लिखिए, IA number 526 of 21 has been preferred for early hearing of this appeal. It appears that the appeal is of 2017 and in its own chronology, it is most likely to be listed under the heading for hearing. Stop. Office to take steps for listing it under the heading for hearing in the next month as per chronology. I this board of
Item number 4, appeal number 242 of 2017, Mr. Asim Kumar Chandi for the appellant, Mr. Varan Velutia for the respondent.
Now, in this case, Your Lordship, I am for the respondent and I have filed an IA for payment of arrears, Your Lordship. If Your Lordship may kindly have a look to Annexure A for a moment.
the maintenance was awarded by the family court or our order, by our order.
The family court was awarded by the family court, but this honorable court has taken indulgence of the matter. Annexure A may kindly be seen, Your Lordship, for a moment. Pursuant to Annexure A, Your Lordship, 25, Annexure A, page 6. Annexure A of the IA, page 6.
We want to know that whether you have filed any enforcement case, execution case before the family court.
Yes, we have filed before the family court. It is pending, Your Lordship. It is pending.
Get it executed. We will ask for a report from the family court as to what is the status of that execution case. That will expedite your maintenance arrears.
As Your Lordship, since there was an order of this honorable court, and pursuant to that, 25,000 was paid.
Give the number of that miscellaneous case.
I don't have the number with me, Your Lordship. I'll have to ask the respondent, Your Lordship, because exact number is not with me, Your Lordship. But I am being informed, Your Lordship, that they have filed execution case, Your Lordship.
You are for the wife?
Yes, I am for the wife, Your Lordship.
So wife must have filed for execution.
Actually, Your Lordship, the counsel of the court below, Your Lordship, must be knowing about the execution case number, Your Lordship. I am not knowing the number, Your Lordship. I am sorry for that.
The information within half an hour or 2 hours and supply it to the court master. We will leave the space blank. It will be indicated what is the miscellaneous case number.
And moreover, if Your Lordship may kindly appreciate one aspect of the matter, that in the divorce judgment, specific order was there, Your Lordship, to pay 10,000 as litigation cost and 3,000 as cost, Your Lordship. That amount has also not been paid till date.
There is an execution case pending. We will ask for the status of that execution case from the family.
The problem is that, Your Lordship, in the state of Bihar, Your Lordship, the maintenance order was passed.
Oh.
And thereafter, Your Lordship, Annexure A was passed by this honorable court.
It's item 4.
Yes, item 4.
Yes.
Who is
So
for
pursuant
the...
to Annexure, yes.
Now, in this matter, Lordship, I would like to say something. That in a 498A case, the he was punished, Lordship, and there is no chance of, Lordship, that they can live together. And in other cases also there are series.
That's a different story, Mr. Khan. We want to know whether maintenance arrears have been paid by you or not. We had also made an arrangement by our order dated 4 December 2019.
Pursuant to the last order, Lordship, perhaps some amount has been paid.
25,000 has been paid, Your Lordship.
Yes.
Thereafter,
filed-
97,000 has come into till date.
Mr. Khan, you filed a reply to this IA 232 of 20.
We'll file Lordship that reply to the IU.
And indicate as to how much is the outstanding arrears and how you intend to pay. Follow?
I'll do Lordship. That's. And Mr. Siddharth, you served the copy of that IU.
Probably the copy has been served to the previous council because Mr. Ajit Kumar was appearing on the last occasion before Mr. Khan was appearing. Probably Mr. Khan has appeared after NOC has been taken, Mr. Ajit Kumar.
Very well. So you serve it upon him during this week.
Yes, sir, I'll serve.
Mr. Siddharth Royal and counsel for the respondent Y undertakes to serve copy of the IA number 332 of 21 upon the counsel for the appellant Mr. Muhammad Mukhtar Khan. You write Muhammad or only Mukhtar Khan?
MD Mukhtar Khan, that's Muhammad Arsi Mukhtar Khan.
Mukhtar Khan. Stop. Mr. Khan undertakes to submit that he would be filing a reply to the IA within 2 weeks.
Some longer time may be given, Lordship. He's in custody and we'll have to take.
Copy within this week, Lisha. Within this week, by Friday. 3 weeks' time.
Lordship.
Please take care of that. It appears that otherwise the appeal is ripe for hearing and is of the year 2017. Office to take steps for listing of the appeal under the heading for hearing as per its chronology in the next month.
Obliged, Lordship. So obliged, Lordship.
Item 5, first appeal number 351 of 2017, Mr. Krishman for document, Mr. Pandey.
Lordship, in this case, I am paying for short parcel. A very short parcel since Mr. Anil Kumar senior is on leg in another court. That's not
We are appealing for responder 1, 2, and 3.
Okay. Who is on left?
Mr. Senior Advocate Anil Kumar.
Very good.
What possible?
Item 6, first appeal number 277 of 2018, Mr. Kumar for document, Mr. Ravi Siyam for the response.
Lordship, item number 6, Lordship.
Yes, item number 6.
Lordship, I appear on behalf of the appellant. Appellant, Lordship, is a first appeal, Lordship.
No. Whether you have taken steps for substitution of respondent number 5.
Lordship, पता Lordship करने गया, पते नहीं, कोई एयर्स का नाम ही नहीं बता रहा Lordship, इसलिए ऑलरेडी अपोजिट रेस्पोंडेंट आर एपियर Lordship, ये अगर बता देते तो फाइल करवा देते. Respondent आर एपियर Lordship.
हाँ, उन्हीं से पूछ रहे हैं.
My lord, I am appearing for the respondent number 1, 2, and 3, my lord.
Do you can you inform the name of the legal heirs of the deceased respondent number 5 to the council for appellant?
I will inform my respondent for whom I am appearing, my lord. If they will provide me, my lord, I will assist this court, my lord, and will provide the same name.
So you ask those information and supply it to him.
Same information I will provide to my learned friend, my lord, counsel, my lord.
We are simply passing it over for the day.
My lord.
By next Wednesday, you inform him so that he can take time for his substitution.
Today itself I will inform them, my lord.
Pass over for the day.
Item number 7, PA number 47 of 2019, along with item number 18, the round number for the appellant.
May it please, my lord. there is an IA for condonation of delay, Malaj. IA number 8, Malaj. The delay is of a small period, Malaj. The respondents are appearing.
Mr. Rakesh Sharma, who is appearing?
Yes, Your Honor. I am appearing on behalf of the respondent, Your Honor.
So, any objection? Delay is minor?
No objection, Your Honor.
Very well. Door number 7 and 8 will liquid. Third learned counsel for the parties on the prayer for condonation of delay of 14 and 15 days respectively in preferring the memo in these two memo of appeals made through IA numbers 878 of 21 and 880 of 21. There is no objection to the prayer. The delay is minor, and as such, there is no objection to the prayer for condonation of delay. As such, the counsel for the respondent does not seriously object to the prayer for condonation of delay. So, on consideration of the explanation furnished by the appellant and upon hearing the parties, delay and on being satisfied, delay being minor is condoned. IA stands disposed of. Let the matter, both the IA stand disposed of. Let the matters appear under the heading for admission.
Mr. Lamba, you should Malaj, we'll take instruction, Malaj. We'll take instruction.
Rahul Lamba, and counsel for the appellant would also seek instruction as to the tax effect of the whether it falls within the monetary limit for preference.
Malaj. Much
2 weeks. After 2 weeks.
Item number 9. First appeal number 102 for the 19th. Mr. Saket Kumar for the appellant. Mr. Sanjay Kumar for the respondent.
I am appearing for the appellant, Lordship. This is a case. There is a delay
on behalf of opposite party number respondent.
There is an IA for condonation of delay. 61 days there is a delay, Lordship.
So the marriage is of 1994. The parties are to go for mediation. There are a number of cases between them.
Yes, Lordship. There is very bad blood between the parties. Number of cases running.
So they should participate in a mediation process at Jhalsa. We will condone the delay. Delay is not an issue.
I have objection regarding the delay, my lord, because my lord maintenance amount as yet, my lord, 5.5 lakhs, my lord, he has not paid, my lord, for which, my lord.
For which have you filed any execution?
To lower court में हुजूर हुआ वो anticipatory bail में actually, my lord, direction has been given by this honorable court.
May I submit something, Lordship?
Yes.
Lordship, in this case, the first appeal, Lordship, in the matrimonial suit, there is one exhibit 1, Lordship, where the parties have compromised the entire suit for the rupees 350,000. 3,50,000 में पूरा entirety में compromise हो गया है हुजूर. Exhibit 1 इनका है हुजूर. Joint compromise petition wife and husband file किए हुजूर. ये paragraph 10 of the judgment में mention भी है हुजूर.
You can rely upon those documents during mediation.
हाँ हुजूर. ये ground raise किए थे इसलिए हुजूर हम बोले, नहीं तो हम नहीं बोल रहे.
नहीं, in a matrimonial case, we do not consider the issue of limitation as very inhibiting, because basically the dispute is to be resolved.
Yes, Lordship.
23 साल की बच्ची हो गई है हुजूर, विवाह योग्य है, ये कुछ ध्यान नहीं दे रहे हैं हुजूर वहाँ पर.
Husband is alleging adultery, Lordship. Wife has filed a case of bigamy, Lordship. The case of bigamy.
Second marriage भी कर चुके हैं, उनसे भी 2 बच्चा है, उसको भी छोड़ दिया है हुजूर.
Criminal
case wife फाइल की थी बाइगेमी का, उनका केस फेल हुआ. 498 का केस में हमको सजा हुआ. उसके बाद हमारे माँ को मारे, उसमें ये केस हुआ जो कि हम लोग किए थे. ये बहुत सारा केस चल रहा है दोनों के बीच. हम लोग एलेज किए हैं कि वो किसी और के साथ रहती हैं, वो एलेज किए हैं कि हम किसी और के साथ शादी कर लिए हैं.
All the more reason for both the parties to settle it.
There is only way that they can settle out of court because they can not resume the matrimonial life, Lordship, because there is much sourness between the parties.
In a mediation proceeding, both the results are possible. So,
Yes, Lordship.
That everybody knows, you also know.
Yes, Lordship.
So we can't predict that it would end up in divorce only or either way. But the recourse to mediation is always preferable in a matrimonial dispute.
Yes,
Otherwise,
Lordship.
one party.
Yes, Lordship.
And nobody gains. So you suggest a date when we can direct both of them to appear at Jhalsa physically. Today is 9th. If they
Yes,
can
Lordship.
appear on 22nd or 23rd February.
मार्च का हुजूर डेट दिया जाए ना, हुजूर देवघर खबर कर देंगे वो लोग, पता नहीं किस कंडीशन में, बहुत दिन से इंफॉर्मेशन भी नहीं मिल पाया हुजूर। मार्च में, फर्स्ट वीक ऑफ मार्च में।
No purpose is going to be solved to delay the commencement of mediation.
Obliged, Lordship. Then please give me, Lordship, any date.
सैटरडे का डेट देते हैं 19 फरवरी का डेट देते हैं।
19 फरवरी से जल्दी हो जाएगा, जो थोड़ा 25 या 26 को दे दीजिए।
चलिए 25। Third learned counsel for the parties on the prayer for condolence.
इसमें हुजूर एक प्रेयर था, ये प्रेयर कर रहे हैं कि माँ बेटी को आने का खर्चा हुजूर कम से कम इनको प्रोवाइड करना चाहिए।
So we provide, that goes without saying. We will indicate on the prayer for condonation of delay of 61 days in preferring the instant memo of appeal made through IU number 8635 of 2019. Appellant husband has taken a paucity of money in has explained that due to that the appellant that the delay has occasioned as the appellant had to arrange money for preferring this appeal. Stop. Then counsel for the appellant submits that the marriage is of the year 1994 and there are numerous cases between the parties. Stop. Appellant's plea for divorce has been dismissed by the impugned judgment rendered by the learned family court, Devghar. Stop. Therefore, delay may be condoned so that the main matrimonial issue can be decided on merits. Stop. Apart from that, he submits that an attempt can be made for amicable settlement of the matrimonial dispute between the parties through mediation at Jhalsa at this appellate stage also. Stop. The appellant is willing to appear physically. Then counsel for the respondent has opposed the prayer. Stop. He has taken a plea that some maintenance amount awarded by the learned family court has not been paid till date. Stop. Be that as it may, on consideration of the grounds urged and upon hearing the counsel for the parties, we are inclined to condone the delay in the interest of justice. Since the parties are also fighting a matrimonial dispute for several years, and the marriage is of the 1994 with offspring born out of the marriage as well. Stop. Accordingly, delay is condoned. Stop. Then counsel for the IA stands disposed of, and counsel for the respondent also agrees to the proposal for mediation between the parties at Jhalsa. Stop. In that view of the matter, let both the parties appear on 25th February 2022 before the learned member secretary Jhalsa at 10:30 a.m. Stop. Learned member secretary can be approached on the following numbers. Stop. On their appearance, the matter be placed before the learned mediator for undertaking the exercise. So both the parties are expected to cooperate with an open mind and attend each of the sittings. So, appellant husband shall pay a sum of rupees 1,500 on as towards travelling and incidental expense on each date the respondent attends the mediation proceedings, in the presence of current mediator Jalsa. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. Matter be listed in the week of third April 2022.
और उधर झालसा में 26 को रहेगा हुजूर
25
25
5th of April, on 5th of April.
Item number 10, LP number 3 for the 19th. This must be for the appellant.
I am for the appellant in this case, Your Lordship. Your Lordship, on 13/1/2021, we have filed the notices, Your Lordship, upon the respondent number 1.
Respondent number 1 has appeared.
Lordship, as per their status, Your Lordship, they have not appeared, Your Lordship.
Service report for AD has not been received. The requisites for speed post was not filed. Our tracking report from registered post shows the consignment has been delivered. So let us await the service report.
My Lord.
Service, so this relates to pension now. So, it appears that pursuant to the order dated 5th January 2022, neither service report nor AD has been received as yet, though tracking report of the registered cover shows consignment delivered. Stop. Awaiting service report. Matter be listed in the week of 28th February 2022. Mr. Sudarshan Srivastav appears for the respondent.
Your Lordship, one fact that this respondent number 2 and 3, I think the state should transpose him as a appellant or they represent them.
Anyway,
they are state officials.
Mr. Dubey will take
Yes, Your Lordship. For that reason, notices are waived on the earlier date, Your Lordship.
So whether it is necessary to transpose them, you consider and make a request.
Item number 19, Mr. Amrit Raj is for the Mr. Munir for the.
Hello, I appear for the appellant in this case, correct? Serial number 11, Malaks.
Yes.
Malaks, in the last occasion, Malaks had inquired as to the status of connected, whether any LP has been preferred in the connected writ petition funds.
Yes.
We have inquired from the department, Malaks, and LP has been preferred numbering 182 of 2020, Malaks. And that is presently pending in the Lavazima board itself, Malaks.
this appeal has been assigned to us.
Yes, my lord. This particular appeal has assigned, my lord.
So that will also have to be assigned,
My lord.
become listed
My
on
lord.
our own.
The department, some other government council is appearing in that matter, my lords. But yesterday I had a talk with the concerned council, and he has assured that he will be mentioning before the bench, my lords, for listing and assigning, my lords. And my lords, I just want to mention one more thing, my lords. There was another LPA, my lords, 496 of 19.
Yes.
In that matter, my lords, the issue was relating to age of the Ayush doctors, my lords. And that is for final disposal tomorrow, my lords, 10th of February, my lords, before DP1, my lords.
Very well. So, whatever would be the fate of that LPA tomorrow, if at all it has any bearing upon these appeals, that you can bring it, either parties can bring it. Of course.
No, that is relating to age of retirement. This is for pay scale.
I understand. So, we will adjourn this case for another 2 weeks. Meanwhile, get the other appeal listed before the appropriate bench, and if it is assigned to us, then it will be tagged together.
My lords.
Then counsel for the appellant, Mr. Toko, SC LNC 3.
SC7, my lords. Now,
SC7.
my lords.
7. Submits on instructions that the other LPA number 182 of 2021 is pending before the
2020, my lords. 2020, my lords.
182 of 2020 is pending before the Lavazima board. Steps are being taken by the State Council for listing it before the appropriate bench. The present matter may be adjourned for 2 weeks so that the said LPA can also be tagged along with the instant appeal. As such, the matter is adjourned for 2 weeks. For the other side, Mr. Manoj Sharma.
Objection.
Yes.
Item 12. First appeal number 19 of 2020. Mr. Shankar Singh for the appellant.
My Lordship, I am appearing on behalf of the appellant, my Lordship. The present IE application filed for the condonation of delay of 11 days, my Lordship.
Are you aware of this report?
Yes, my Lordship. Several notices were sent to the respondent, but I think, my Lordship, intentionally he has not appeared in this case. My Lordship.
So, steps for substituted service, file an IA.
ऑर्डर सीट में भी जो नीचे कोर्ट का आया हुआ उसमें भी एक केवल WS फाइल किए हैं और क्रॉस एग्जामिनेशन अपीलेंट का लेने के बाद उसमें कभी अटेंड भी नहीं किए हैं ऑर्डर सीट में भी आया वो जो
You will have to say all those things in your IA for a request for substituted service through paper publication. Then the court will consider whether the service is being deliberately avoided, and then, if necessary, substituted publication would be done.
Okay, ma'am.
It appears that despite press notices on the sole respondent, service could not be effected as neither undelivered registered cover with AD nor undelivered speed post has been returned. As undelivered registered cover with AD and undelivered speed post has been returned with the endorsement, addressee left without information. The appellant counsel for the appellant seeks time to take steps for substituted service of notice. As prayed for, matter is adjourned for 2 weeks.
I would like
Mr. Shankar Singh for appellant.
Item number 13, WPT number 740 of 2011 of
Your Lordship, I am GC to Mr. Anup Kumar Mehta. He is appearing before court number 7. If a passover or an adjournment as...
May I submit one thing, Your Lordship? As per the last order, Lordship, dated 1/3/2021, Your Lordship, Civil appeal is still pending, Your Lordship. Civil appeal number 6043 of 2014 is still pending, Your Lordship.
Civil appeal number is
6043 of 14. I have seen order dated 11/5/2016, Your Lordship.
They have filed a supplementary affidavit stating that some more assessment orders have been passed for certain years. So, Lord Counsel, for the petitioner, what do you propose? Should we adjourn it, awaiting the outcome of the civil appeal? Because it's a matter of 2011 or not admitted for hearing.
Your Lordship, my senior is appearing, and Your Lordship, if as Your Lordship pleases.
Pass over for one or two cases.
Obliged, Your Lordship.
Mr. Dubey, you also remain.
My Lord.
Item 14, WPT number 556 of 2016. Mr. Rajkumar for the petitioner. Mr. Apan Banerjee.
Your Lordship, I am appearing in this case.
Yes.
Your Lordship, in this case, the petitioner pays for quashing of the order dated 5/1/2016, wherein the ex parte order has been passed for a period of assessment period of 2012-13 by the respondent number 3, Your Lordship. In which it has been asked by the petitioner to produce the papers and subsequently quashing of the demand notice also dated 5/1/2016, which demand has been raised as per this order, Your Lordship. Thereupon, further prayer this is a threefold prayer. Further is to pass a fresh assessment order for the period 2012 and 13, Your Lordship.
Who is for the state?
I am appearing, Lord.
So, in your counter affidavit, have you not taken the plea of alternative remedy of appeal? What is the provision for appeal under the VAT Act?
Section 79, Lord. Yeah.
Chapter 9.
Yes, Lord.
Mrs. Majumdar, writ petition is not maintainable against this order because there is a remedy of
Yes, Your Lordship.
So,
But then, Your Lordship,
uh,
yes, Your Lordship.
so you have perhaps erroneously filed this writ petition without availing the appellate remedy. And they had to pass the order because it would have got time barred.
Yes. Yes, Your Lordship.
So,
But now, Your Lordship,
now or what? The 2016 matter, you have not taken enough steps for getting it disposed of. It is up to you to explain the delay before the appellate authority.
that is true. But that delay,
79.
Your Lordship, that is the only, this is not.
You go and explain.
Although, Your Lordship, in this case, I'll explain, but that be only that humble prayer before Your Lordship, that will be mentioned because we have preferred the writ application, although it's a wrong remedy, but we have preferred. But they have also in their counter affidavit not taken the stand. They themselves have admitted, Your Lordship, that in their counter affidavit, Your Lordship, in para.
Anyway, you take all whatever legal.
In para 10 that they have filed a time petition, it was not in prescribed manner. That's why they have, their ground for my rejection is ex parte order is passed, they have not filed a time petition in a prescribed manner, Your Lordship. Although time petition was filed by us to produce the books and all, Your Lordship. But now if I go for alternative remedy, the only period remediation will, that be observed, Your Lordship. Only I want that observed.
This petition was preferred with the following prayer. Stop. So respondent state has filed counter affidavit and taken a categorical plea that the revenue, the assessing authority acted as per the provisions of the Jharkhand JVAT Act 2005 as the proceedings would have been time barred by 31st March 2016. Stop. This petitioner was provided 3 opportunities which satisfies the procedural requirement and compliance of natural justice. Stop. When counsel for the state has taken a plea of alternative remedy of appeal against the order of assessment as is available under section 79 under chapter 9 Roman of the JVAT Act 2005. Stop. Then counsel for the petitioner submits that the appeal was to be preferred within a period of 30 days. However, the appellate authority has the power to condone the delay if sufficient reasons are explained. Stop. An observation to that effect may be made, giving liberty to the petitioner to avail the alternative remedy of appeal. Stop. Para. It appears on consideration of the materials on record that the impugned order passed by the impugned assessment order passed by the Deputy Commissioner of Commercial Taxes, Bokaro Circle, respondent number 3, is an appealable order under section 79 of the JVAT Act 2005, which reads as under 79 quotes. Stop. The Act also, and the provision also contains a power of condonation of delay. Stop. Since there is an alternative remedy of appeal, we are not inclined to entertain the writ petition. Stop. The writ petition is dismissed as withdrawn, leaving it open for the petitioner to pursue the appellate remedy. and also explain the delay before the appellate authority on grounds of pendency of the writ petition, which may be considered strictly in accordance with law. Let it be made clear that we have not gone into the merits of the case of the parties. So and so stands closed. Disposed of, leaving it open with liberty to the petitioner to pursue the remedy of appeal.
Item 50, WCP number 136. Along with item number 60.
Lordship, I am for the petitioner in this matter, Lordship. Lordship,
Yes.
yesterday I have sent email for adjournment in this matter.
On what ground?
Lordship, by some mistake, Lordship, files are not traceable at our office, Lordship. So I'm
You have not-
apologizing for this.
Not been filed.
Lordship, no required to file rejoinder in this matter, Lordship.
You took time on the last day. Anyway, so how much time do you require?
Lordship, it may come after 2 weeks. In meantime, we'll restore the file.
On the request of learned counsel for the petitioner, matter is adjourned for 2 weeks. Stop. An request through email was also circulated yesterday. With copy to the other side. इसको पहले कर दीजिए. Request for adjournment was made by the counsel for the petitioner through email circulated yesterday with copy to the other side. As prayed for, list the matter after 2 weeks. However, no further adjournment should be sought.
Lord, my name may be displayed in the call list, my lord.
AG2 for the state, let his name appear in place of.
Item 70, WPS number 2940 of charge 70, Mr. Abhishek Kumar of the petitioner, Mr. Rajesh Sinha of the
May please, my lords, I am appearing on behalf of the petitioner.
Yes.
Lord, the order in... May I proceed, my lords?
Yes.
Lord, the order and the challenge, the order dated 13/2/2017 at Annexure 5, page 38, passed by the learned CAT, my lords, whereby the claim of the petitioner for grant of promotion has been defeated on the ground that his ACRs bears good, and on that ground, that being an adverse entry, the petitioner is not entitled for his promotion, grant of promotion. My lords, the sole question which arises for my lord's kind consideration in this petition is whether the respondent authorities can deny the benefit of promotion to the petitioner on the ground of adverse entry made in his SCR, which was not even communicated to the petitioner within the reasonable period of time. That is the only sole question, my lords. Because admittedly, they have...
What was the adverse entry?
My lords, the petitioner was granted good in his ACR for in the year 2004, 5, 5, 6 and 6, 7, which was communicated to him in the year 2011. In fact, my lords, the entry of good, my lords, that is an adverse entry because that has eliminated the petitioner to be considered for his consideration on the post of for his promotion, my lords. That has eliminated his promotion case of promotion, my lords.
Has the petitioner retired or is still serving?
My lord, he has retired in the year 2018. July 2018, he has retired, my lords.
Then we will hear it. We will hear it.
My lord, I'm covered, my lord. This matter is entirely covered. I am having a similar case has been decided. 2009, volume 16, 146. My lord, there also the petitioner, he was a member of my lord's Indian Postal Service, my lords.
We will look into that judgment which you are relying. We will hear it very soon.
Milords, it's a very small, it's a covered matter, Milords. I was only praying, I was only relying on a short judgment, Milords. Whether the entries which
Have you
is
supplied that judgment?
no, Milords, I'm so sorry.
So
I haven't.
when you ask the court to rely, to consider a judgment and you do not supply it beforehand, we will list it at an early date. Don't worry.
As your Milords deem fits.
Petition is admitted for hearing. Hearings are complete. Stop. Rule returnable 3 months. Office takes steps for this listing.
My appearance may be noted.
This is Vibha Bakshi for respondent. Let her name appear in the cause list henceforth for the respondent.
WPS number 4673 of
Then counsel for the parties should submit written notes containing the list of dates and decisions on which they seek to rely at least a week before the scheduled date of hearing to the court master. You tell Mr. Abhishek also. This is yes.
Item 18, WPS number 4673 of 2017, Mr. Niranjan Kumar for the petitioner, Mr. Rani Sinha for the...
I am appearing on behalf of petitioner, my lord.
Yes.
The improved order is page 111, 113, my lord. And it's a 111 to 113.
111 to 113 is the impugned order.
Yes, my lord. The core is that I was my case of compassionate appointment was rejected on the ground of that I was a married son. I had page 49, my lord. Page 49. Further, as per the clarification issued by postal director letter number so and so, the married son cannot be considered as a dependent of the government servant. Hence, your case should not be considered for.
My lord, I appear for the respondent, my lord.
Come on,
Later on,
my lord.
Later on, my lord, during the pendency of court,
just a minute.
My lord, I have filed the counter affidavit, my lord.
Yes.
And in paragraph 9 of my counter affidavit, my lord, I have specifically stated, my lord, that his father died in the year 2000, in the year 1992, my lord, 4/7/1992. My lord, the date of birth of this petitioner is 5/1/1985. My lord, he attains the majority in the year 2003. My lord, but he applied for compassionate appointment, my lord, after 3 years. My lord, that is after lapse of 14 years, my lord. So therefore, my lord, his case could not be considered, my lord.
my lord, the case is not on rejected by the learned cat, my lord. The ground is that the department has revised the circular as page 146, my lord. Kindly, I request your lordship to refer page 146, my lord. The ground of compassionate appointment that I was a married son, and that policy has been withdrawn, my lord. The case is that,
we are saying something, please listen to us.
my lord.
Tell us, as per the settled principles of compassionate appointment,
Yes, my lord.
Nagpal case and all,
Yes.
is there any time limit for seeking compassionate appointment, or it can be done at indefinite length?
Yes, my lord. The department has a policy that is at page, my lord, 138 and 141, my lord. Kindly refer page 138 and 141, my lord. There is
What does
policy
that
that a case of compassionate appointment can be considered without time limit. Page 141, my lord.
That the department may say, but a court will not entertain a plea for compassionate appointment so long.
kindly refer, my lord, page 141, my lord, policy, DOPT policy, item number 36, 38, my lord. Is there any time limit for consideration in case of compensation and appointment? Clarification is, my lord, subject to availability of a vacancy and instruction on the subject issued by the department as amended from time to time. Any application for compassionate appointment can be considered without any time limit, subject to the merit of each case. My lord, the question is not the case has already been considered by the respondent. They have rejected only on the ground of merits.
Therefore, your case was considered.
Yes,
Therefore, your case was considered by the department on points basis and rejected
on the ground of merits, only on merits, and that policy has been withdrawn.
As a writ court, he would not allow such a belated claim for compassionate appointment.
But they have not rejected on the ground of belated or delay. They have only rejected my case on the ground of merits. And later on, my only claim is that, my lord, the respondent has revised the policy, which is circular dated 5/9/2016 at page 146, my lord. And that circular is effective from retrospectively. The question of law only decided to that the Honorable Tribunal has rejected my case that this circular is prospectively. They have wrongly interpreted the circular. The actual position that circular is effective from retrospectively. The last para of the circular, page 146, my lord, kindly be seen. Page 146, 147, my lord. The case of compassionate appointment rejected solely on the ground of marital status in terms of frequently so and so during the intervening period with effect from 30/5/13 से 25/2015 in respect of marriage may be reopened, reconsidered against vacancy occurring after issue of this OM. And my case was rejected on 28/2015, my lord, and is fully covered under this circular. Only the question is to be decided.
Your case was considered on points basis. You were less than the last recommended candidate. And
no, my lord, rejected only on the ground of merit. If I was not married,
67 points. The last candidate got 69 points.
Yes, my lord.
So, on that count also, you did not secure more points than the last selected candidate.
But
that also considered that.
But as per existing policy, my lord,
though the
case can be reconsidered after next year, my lord.
No, we can't.
There is clear policy, my lord.
Wrong in the cat's order, which requires interference.
Kindly see, my lord, policy number 26, my lord, at page 138. 138, my lord.
Yes.
138. Serial 26, my lord.
Yes.
If compulsory appointment cannot be given in a year, can it be considered in the next recruitment year? The clarification is, my lord, yes. There is no time limit for compassionate appointment. A request for compassionate appointment can be carried forwarded to the next or more years, but the total compassionate appointment made in a year should not be exceed 5% limit of the total vacancy. The only question is to be decided that, my lord, the learned tribunal has dismissed my OA on the ground that circular is prospectively. But there is clear that circular is retrospectively, and my case decided to be decided by the department. But when the case is sub judice, they did not decide my case as per that circular. I humbly pray, my lord, that my case allowed or reconsider my case of a compassionate appointment.
Very well. Likhiye. Third Land Counsel for the petitioner, Mr. Rajan Prasad, and Learned Counsel for Union of India, Mr. Vinod Singh. Stop. Impugned herein is the order of rejection of OA number so and so, order dated so and so, rejecting OA number so and so, dismissing OA number so and so, annexure 4 by the learned CAT Patna bench, circuit bench at Ranchi, and also the order dated 22nd November 2016, rejecting the review application number so and so, arising out of the same OA, annexure 6. Stop. Briefly stated, the facts of the case are in a narrow canvas. Petitioner's father died in harness in the year 1992. Stop. Petitioner's date of birth is 5th January 1985. Stop. He attained majority in 2003 and preferred the claim for compassionate appointment 3 years thereafter. Stop. The claim was considered and on points on the prescribed parameters, he obtained 67 points as compared out of 115 points as compared to the last selected candidate who got 69 points. Stop. The claim was rejected by the order dated 28 January 2015. Learned CAT considered the case of the petitioner and rejected the OA holding as under. ये कितना बार ये OA का order annex किया हुआ है? OA का order 5 बार annex किया हुआ है, same order. Annexure 4 से copy कर लीजिए. Para 1 से लेके तक single. Then counsel for the petitioner submits, relying upon page 141. A clarification as to the query at serial number 38. Containing annexure A by 21, i.e. frequently asked questions, within bracket FAQ small s, bracket close, on compassionate appointment issued by the Department of Personnel and Training, that there is no time limit for entertaining an application for compassionate appointment. Now, relying upon an office memorandum, annexure A22, annexure 22, dated 5th September 2016, issued by the Department of Personnel and Training, Ministry of Personnel, Public Grievances and Pensions, Government of India. Then counsel for the petitioner submits that the married sons of the deceased employee have been considered as eligible for compassionate appointment if if he otherwise fulfills the criteria laid down in the department's OM dated 16 January 2013. Stop. However, this would be effective from the date of the FAQ 25th February 2015 and cases of compassionate appointment already settled with respect to FAQ dated 30th May 2013 may not be reopened. Stop. Learned counsel for the petitioner submits that therefore the claim of the petitioner was not time barred, and further, since it has been rejected on the ground that he is a married, also on the ground that he is a married son, the same needs to be reconsidered in the light of the latest circular, Annexure 22. Stop. We have learned counsel for the respondent. The impugned order may therefore be set aside. Learned counsel for the respondent has filed a counter affidavit and strongly opposed the prayer. He submits that petitioner's case was belated as per the chronology of dates and events mentioned above. Still, the department considered the claim on the prescribed parameters and found him to be and he was found lacking in merit on points basis, as the last selected candidate had secured 69 out of 115 points in PA cadre, whereas the petitioner had secured 67 points. So, the case of the petitioner was rejected on 28th January 2015. And as per the circular dated 5th September 2016, the cases of compassionate appointment which were already settled before 25th February 2015 could not be reopened. Stop. As
No, my lord, kindly, I pray, my lord. The case is to be considered para 4, my lord, page 2, page 147, my lord. Clearly the case will be reconsidered, my lord. Page 147, my lord. The case of compassionate appointment rejected solely on the ground of married son in term of frequent question exam. Intervening period with effect from 30 से 25 to 15 in respect of married son may be reopened reconsidered. Again, vacancy occurring after the of this order. My case was rejected on 15 and case would be taken up to 25 to 15. Therefore, my case is able to reconsideration, my lord. Kindly see, my lord.
Yes. Learned counsel, उसके बाद लिखिए. Learned counsel for the respondent further submits that learned tribunal has duly considered all the contentions raised by the petitioner and rightly held that the rejection of the claim for compassionate appointment does not need interference as it cannot be claimed as a matter of right. Stop. It is submitted that the claim of the petitioner was not rejected only on the ground of being a married son. Stop. Learned counsel for the petitioner in reply has relied upon para 4 of the circular dated 5th September 2016, as per which cases of compassionate appointment rejected solely on the grounds of marital status in terms of FAQ number 13 dated 30th May 2013 during the intervening period with effect from 30th May 2013 to 25th February 2015 may be reopened, reconsidered against vacancies occurring after issue of this OM. Stop. As such, the case of the petitioner can be reconsidered on this count. Stop. We have considered the submission of learned counsel for the parties and the grounds urged in support of the challenge. Stop. Upon consideration of the materials on record relied upon by the rival parties, it is clear that the petitioner's claim for compassionate appointment was made in the year 2006 after he attained majority in 2003 and much after the death of his father on 7th May 1992 in Harness. Stop. Though the claim was belated as per the principles, as per the well-settled principles governing compassionate appointment laid down by the apex court in the case of so-and-so, Umesh Nagpal, uska citation de dijiyega. But the department examined his case on the prescribed parameters and found him lacking in merit as he had secured only 67 points out of 115 points, whereas the last candidate in PA cadre had secured 69 points. Stop. The claim of the petitioner therefore doesn't appear to have been rejected only on the ground that he was a married son. Had it been so, the case was not required to be examined on the prescribed parameters, that is point basis. Stop. Relying upon the circular dated 8 January 2016, 5th September 2016, petitioner seeks reopening of his case, treating the rejection as solely on the ground of being a married son. Learned Tribunal has considered all aspects of the, on perusal of the impugned order passed by the Learned Tribunal. It is apparent that the Learned Tribunal has considered the case of the petitioner has taken into consideration all the grounds raised by the petitioner. Stop. In the backdrop of facts and the relevant circulars discussed above, we do not find any infirmity in the order of the learned CAT, which deserves interference in exercise of our writ jurisdiction. Accordingly, the writ petition is dismissed as being devoid of merits.
Right.
And the WPT number 177 of 2021, along with item number 20 and 21. So, the meeting for
Mr. Purmi, just
My lord.
can we take up few matters after these three batch cases?
My lord, after that 3 batch cases, there is one more matter, my lord, NKS.
So we will just gather from the respondent counsel, Mr. P.S. Pati, as to what instruction he has obtained in item 22 after the last
Right, my lord, right, my lord.
and other matters, 2-3 matters, short matters perhaps.
So, my lord, after conclusion of other matters, my lord, this matter will be taken up?
Yes, your matter would be taken up finally after these 3 matters are.
Right, my lord.
Yes, Mr. Mehta, what's your instruction in that passed over matter?
I've just forwarded the present status to your lordship. The matter is still pending as on date, my lord.
So what should we do? We should adjourn it, sign it, or admit it hearing, or what?
In fact, Central Coalfields had also filed civil review applications, and they have been, and in those cases, this honorable court has passed an order. Kindly see Annexure 7 at page 12 of the supplementary affidavit filed on 12/3/21.
12/3/21.
Annexure 7, page 12.
There is one affidavit of
15/7.
15/7/21.
That is later one. Your lordship will have to see the earlier one, my lords.
Okay.
12/3.
12/3. Page 12.
Page 12, my lord. It is submitted at the bar that the issue involves in this matter is being considered by the Supreme Court Civil Appeal 6043. Same matter, my lords. Accordingly, let these matters be listed after disposal of civil appeal. So similar order can be passed.
Mr. Mehta, learned counsel for the petitioner, has referred to the order dated 10th December 2019 passed in Civil Review number 92 of 2011, Central Coalfields Limited versus the State of Jharkhand and others, with 2 other analogous writ petitions preferred by the petitioner Central Coalfields Limited, and submits that the same issue arises in those writ petitions as well, those matters as well. Stop. It is submitted that the coordinate bench of this court has ordered that those matters be listed after disposal of the civil appeal number 6043 of 2014, which involves the issue, in which the same issue involved in these matters, in which the same issue is involved as in the present matters. Stop. Reference para. Reference is made to the previous order dated 1st March 2021. Stop. It appears on the submission of learned counsel for the petitioner that civil appeal number 6043 of 2014 is pending adjudication, pending for before the apex court. Stop. Similar matters have been adjourned by the coordinate bench as per the order at Annexure 7 to this supplementary affidavit dated 12th March 2021. As such, let this matter be also listed after disposal of civil appeal number 6043 of 2000.
Along with civil review, along these 2 matters, my lord?
Along with those civil reviews?
Yes, my lords.
Along with civil review 92 of 2011 and other analogous matters.
I am for the state in this case, Your Lordship.
Mr. Mohan is before 5. Yes, 5 we call for me.
Masterwork case item number 5, first appeal number 351 of 2017, Mr. Mukesh Kumar for the policeman appeal. Mr. Pandey, for the.
Yes, my lord, in this case, my lord, we have filed an IA application for interim custody of the children, my lord.
Your other side is there. Mr. Roy was appearing and it was first called out.
My lord, I'm sorry, my lord, at that time I could not appear. I was on leave. I was arguing in another court, my lord. The interim, yes, Mr. Roy has joined, my lord.
Mr. Roy? Mr. Roy? Mr. PPN Roy, kindly unmute yourself.
Respondent in this case, sir.
Yes. You are representing how many respondents? All the respondents. Mr. Roy? Mr. Roy? Oh, he's not. And 12 years, 17 years and 12 years. Yes, Mr. PPN Roy, appear on the screen. Yes.
We are appearing for this. Yes, we are appearing for the respondent in this case 1, 2, 3.
He has filed, appellant has filed an IA for interim custody.
Yes, my lord.
Of 2 female children, Arya and Sunidhi, aged 17 and 12 years, respectively.
Yes. Now the
So
point.
you respond to this IA?
Yes, we will file counter affidavit.
Yes.
One thing I want to point out for lots of kind consideration. I know,
Yes.
if kindly peruse the judgment passed by the learned court below.
That we will see after you file your reply.
All right, okay.
And we get the present status of their well-being, welfare.
That will also be the necessary, my lord, so far as the adjudication on the issue is concerned, my lord.
Therefore, let him respond, and then if necessary, we will call for a report from the school and the professional.
What I'm submitting for lots of kind consideration is this.
Yes.
In my humble submission, there was a compromise between the parties.
Yes, in spite.
Just made, my dear learned friend, there was compromise between the parties. Now, in the terms and conditions of the compromise was that this appellant will never claim the custody of the child. My lord.
Is it a finding recorded in the impugned judgment?
Yes, I am reading that. Kindly peruse it. Then he just stopped from filing this petition in my humble submission. My lords may kindly see the finding.
No, in that case, if you don't want to file your reply to the IA, then we will consider the IA on the basis of the materials already on record.
No, we file counter also. We'll file with
Then better file it.
My lords, yes.
Learned counsel for the respondent, Mr. Pandey A. Roy, senior counsel. 6, is allowed 2 weeks time.
My four because respondent number 2 in my humble submission had died. Respondent number 2.
So he will take steps if the other parties are already representing him as a legal heir, then no necessity. Otherwise, the appellant will take steps for his substitution.
Substitution is not. Minus the name of respondent number 2, who is father of this respondent number 1, had died.
Therefore, my lord, the name is to be deleted, my lord.
So you, Mr. Roy, you state that in your reply
All right, madam.
And then the appellant's counsel will request for deletion of the name.
Yes,
Madam. 4 weeks time may kindly begin.
4 weeks time is allowed to learn counsel for the respondent, Mr. Pandey and Pipin Roy, to file counter affidavit, to file reply to the IA number
248.
82 of 21.
Oh, yeah, no.
So, matter will be listed after 4 weeks.
Documentary number 2659/2020
Yes, Mr. Pati, what is the status of your instruction?
My lord, in NUX, my lord, WPT 2659.
NKS.
Yes, sorry, my lord, NKS, yes, sorry. My lord, in this case, I have spoken to the officers, my lord. Now, they are of the view that since the ground urged in the earlier case in which the show cause was also quashed, and the present one is also the same. They were of the view, if your lordship will be kind enough to pass the order in similar line, then we'll proceed again in accordance with law. Because in one case, since it is now quashed, so recalling the same in another case, they have some reservation and difficulty. Almost the same ground is there, my lord, except the difference of being section 73 and 74. The earlier case being under section 74, the present case being under section 73. My lord, we'll proceed again in accordance with law as directed in the earlier case, my lord, of the same petitioner. But I was only praying that it may be decided on merits as done in the earlier case, in the earlier round of litigation.
जजमेंट इसमें जो लिखा हुआ है 2021 GSTL इसका कॉपी जरा दीजिए एंड कैश पिछला जजमेंट लगाया है
Lord, in the compilation, my lord.
Yes, yes.
Compilation, the last judgment of in my own case is at page 91, my lord.
Acha, and that decided by us earlier.
My lord, section 70.
Yes, my lord. But only the difference being in that earlier case, the notice was SCN was under section 74. This case it is under 73. So, my lord, I understand only that part finding with regard to section 74. That will not be in this case, subject to what my learned senior friend is. Only that part of the finding may not be here in this case.
2021 54 GSTL has it.
And my lord, that GSTL item is Bharti Airtel.
Bharti.
Bharti Airtel, my lord, I was relying on that on the ground that what Bharti Airtel says that GSTL portal is only a facilitator.
Right.
And my lord, may I submit 2 lines, my lord?
Yes.
My lord, what department is taking a plea in their counter affidavit, and your lordship have also indicated in the last order that department is fixated in the mind that SOCA's notice under 73(1) and for that matter under 74(1) has to be in a computer generated template in the GSTN portal. And what I submitted before my lordship is that the SOCA's notice, the statute does not mandate 73(1) or 74(1) does not mandate a template for a SOCA's notice. It simply says SOCA's notice. Now, if the GSTN portal going beyond the scope of the statute makes a template and department feels that it is fixated by the template, that the difficulties with the department and the GSTN portal. But the law talks about the summary of SOCA's notice, for which summary the DRC 01 format is there.
Format is there. Format is there for the summary, not for the show cause notice. So the contention taken by the revenue in their counter affidavit that they are bound to issue show cause notice in a fixed template or a fixed template in the GST portal is not flowing from the plain language of the statute. Show cause notice and other central authorities also are issuing show cause notice independently without any format. They are issuing the show cause notice as they used to issue. But when it comes to summary, they issue summary in DRC 01 and they upload it in the GST portal. So that limitation of issuing a notice in a format applies only to summary, not the main show cause notice.
Right.
Now,
Rule 142 was also, my lord, quoted before your lordship.
142 is for DRC 01 and GRC 01A, my lord. And my lord, 73.1 and 74.1 is for the show cause notice. Show cause notice per se, 140 rule 142, 1 small a is DRC 01, which is the summary, my lord, of the show cause notice, which is to be uploaded electronically. As your lordship rightly observed on the last occasion, that is to keep a track. The summary is uploaded to keep a track of what proceedings are pending against the SSE or registered person. But that does not mean that the show cause notice has to be in a fixed template. That was a point. And my lord, revenue has also taken a point that the summary is taking care of the show cause notice or requirement of the show cause notice. Yeah, as a matter of fact, the summary is also very vague. And what is not contained in the main show cause notice cannot be part of the summary. That was my submission. And my lord, in my own order, last judgment, your lordship have already observed that summary cannot be substitute of the show cause notice. My lord, kindly see page 91 judgment starts. My lord's judgment starts on page 91. And your lordships have observed at page 98.
Yes.
Last para, my lord, para 17.
Yes.
As observed herein above, the impugned notice completely lacks in fulfilling the ingredient of a proper show cause notice under section 74 of the Act. Proceeding under section 74 of the Act have to be preceded by a proper show cause notice. A summary of show cause notice, my lord, I emphasize, a summary of show cause notice as issued in form GST DRC 01 in terms of rule 142.1 of the GST rules 2017 cannot substitute the requirement of a proper show cause notice. This court, however, is not inclined to be drawn to the issue whether the requirement of issuance of form GST ASMT 10 is a condition for invocation of 73 or section 74 of the GST Act for the purposes of deciding the instant case. This court finds that upon perusal of Annexure 2, which is the statutory form GST DRC 01 issued to the petitioner, although it has been mentioned that there is a mismatch between GSTR 3B and 2A, but that is not sufficient as the foundational allegation for issuance of notice under section 74 is totally missing and the notice continues to be vague. So, my lord, your lordship have already observed that a DRC 01 is a summary. What is not there in the summary cannot be part of the main what is not part of the main show cause notice cannot be part of the summary, and summary show cause notice summary DRC 01 cannot be substituted with show cause notice. So show cause notice is required. And also, my lord, I have observed in the previous para, my lord, page 98 again, my lord, page 98, para 15.
Yes.
The apex court has held, my lord, your lordship, we are reading judgment of Supreme Court in the case of Oryx Fisheries. If I take your lordship to the previous page.
Yes, yes.
Page 97, para 14, my lord. A bare perusal of the impugned show cause notice creates a clear impression that it is a notice issued in a format without even striking out any irrelevant portions and without stating the contraventions committed by the petitioner. That is, whether it's actuated by reason of fraud or willful misstatement or suppression of fact in order to evade tax. Needless to say that the proceedings under Section 74 have a serious connotation as they allege punitive consequences on account of fraud or any willful misstatement, suppression of fact employed by the person chargeable with tax. In absence of clear charge, which the person so alleged is required to answer, the notice is bound to be denied proper opportunity to defend itself. This would entail violation of principles of natural justice, which is a well recognized exception for invocation of jurisdiction despite availability of alternate remedy. In this regard, it is profitable to quote the opinion of the Apex Court in the case of Oryx Fisheries Private Limited Supra at para 2427, wherein the opinion of the Constitutional Bench of the Apex Court in the case of Khem Chand versus Union of India, AIR so and so, has been relied upon as well. Para 24. This court finds that there is a lot of substance in the aforesaid contention. It is well settled that a quasi-judicial authority, while acting in exercise of its statutory power, must act fairly and must act with an open mind while initiating a so-called proceeding. A so-called proceeding is meant to give the person proceeded against a reasonable opportunity of making his objection against the proposed charges indicated in the notice. Expressions like a reasonable opportunity of making objection or a reasonable opportunity of defense have come up for consideration before this court in the context of several statutes. A constitutional bench of this court in Khemchand versus Union of India, of course, in the context of service jurisprudence, reiterated certain principles which are applicable in the present case also. Chief Justice S.R. Das, speaking for the unanimous Constitutional Bench in Khemchand, held that the concept of reasonable opportunity includes various safeguards, and one of them is, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which such charges are based. It is no doubt true that the stage of so cause the person proceeded against must be told the charges against him so that he can take his defense and prove his innocence. It is obvious that at that stage the authority issuing the charge sheet cannot, instead of telling him the charge, confront him with definite conclusions of his alleged guilt. If that is done, it has been done in this instant case, the entire proceeding initiated by the so-called notice gets vitiated by unfairness and bias, and subsequent proceedings becomes an idle ceremony. Then, my lord, next para by your lordship. The apex court has held that the concept of reasonable opportunity includes various safeguards, and one of them is to afford opportunity to the person to deny his guilt and establish innocence, which he can only do if he is told what the charges leveled against him are and the allegations on which the charges are based. It is also true that acts of fraud or suppression are to be specifically pleaded so that it is clear and explicit to the noticee in reply thereto effectively. Then Madam Lasan took his right. Further, in the case of CC versus Brindavan Beverages Private Limited reported in so and so, relied upon by the petitioner, the Apex Court at para 14 of the judgment has held that if the allegations in the show cause notice are not specific and on the contrary vague, lack details and or unintelligible, that is, it's sufficient to hold that noticee was not given proper opportunity to meet the allegations indicated in the show cause notice. We do not agree with the contention of the respondent that the notice ought not to be struck down if, in substance, it contains the matters which a notice must contain. In order to proceed under the provisions of Section 74 of the Act, the specific ingredients enumerated thereunder have to be clearly asserted in the notice so that the noticee has an opportunity to explain and defend himself. My lord, I will pause for a while. In this case also, the irrelevant portions have not been striked out. If your lordship will see the show cause notice or the summary of show cause notice, kindly see, my lord. I'll have a glimpse how I will say that the ratio of the judgment also applies to the cases under 73. In my case particularly, my lord, kindly have a writ petition number 1. I'm sorry. Kindly have, my lord, page Annexure 1, page 97, my lord.
That was withdrawn, then page 102 came, no? No.
No, my
Earlier,
lord, this is surviving. This is surviving.
This is surviving.
And my lord, page number 100 is surviving.
102 was withdrawn.
My lord, 102 was withdrawn. And 105 is already withdrawn, my lord.
Hmm.
So, my lord, kindly have page 97, annexure 1.
Yes.
My lord, what is the allegation against me? It is only a replica of the provision of section 73(1). It is a mechanical reproduction of what is there in 73(1). It has come to my notice that tax due has not been paid, or short paid, or refund has been released erroneously, or input as credit has been wrongly availed or utilized by you, or the amount paid by you through the above referred application for intimation of voluntary payment for reasons and other details mentioned in the annexure of the aforesaid tax period. Therefore, you are directed to furnish a reply along with supporting documents as evidence in support of your claim by the date mentioned in the table below. Next page, my lord. You may appear before the undersigned for personal hearing, either in person or through authorized representative, for representing your case on the date, time, and venue if mentioned in the table below. Please note that besides tax, you are also liable to pay interest and penalty in accordance with the provisions of the Act. You will make payment of the tax stated above, along with up-to-date interest within 30 days of the issue of this notice with applicable penalty. Then proceeding may be deemed to have been concluded. Then, my lord, details of personal hearing, all these are here. The demand details. Turnover is there.
Yes.
Period is there, my lord. And the amount of demand is there. Penalty, interest is there. What is the charge against me? That is nowhere stated. What is my offense? What I have committed? What I am to meet? What I am to defend? The show cause notice totally silent. So my submission is, my lord, the show cause notice is a vague show cause notice. It is in violation of natural justice. It does not disclose the offense committed by me, on what ground the tax is sought to be demanded from me. The show cause notice does not say anything about it. So this show cause notice is not a notice mandated under 73(1) as held by Supreme Court in so many judgments, including, my lord, in the case of Mapatlal Industries and Gorkha Security. In the case of Gorkha Security also, my lord, the Honorable Apex Court had the occasion to deal with under the service jurisprudence that what a show cause notice must constitute. And, my lord, in that case, the Supreme Court said, I have separately sent the judgment to your lordship. That is not a violation.
Para 21 and 22 perhaps of that Gorkha Securities.
My lord, just my lord, 1 minute, your lordship. Just I am reading for my para. My lord is very correct, my lord. My lord. Sometimes it surprises me, my lord. Your lordship could say the para number. I have read it, but the para number is not in my mind, my lord. That is page 118, my lord. The judgment is before your lordship. Page 118. Gorkha Security.
In the which volume?
My lord, which is not in the volume, it is separately sent, my lord.
2014 है ना?
2014 9 SCC 105.
निकलवाइए. 2014 9 SCC. Volume 9 SCC.
Page 118. We are concerned with page 118, and my lord, it starts on page 105.
Right.
Para 21, my lord, the bottom para. Contents of the show cause notice.
Yes.
Para 21, the central issue, how it pertains to the requirement of stating the action which is proposed to be taken. The fundamental purpose behind serving of show cause notice is to make the noticee understand the precise case set up against him which he has to meet. That this would require their statement of imputations detailing out the alleged breaches and defaults he has committed, so that he gets an opportunity to rebut the same. Another requirement, according to us, is the nature of action which is proposed to be taken for such a breach. That should be also be stated, so that the notice is able to point out that the proposed action is not warranted in the given case, even if the default breaches complained of are not satisfactorily explained. When it comes to blacklisting, this requirement becomes all the more imperative, having regard to the fact that it is harshest possible action. Next page, my lord. Point 22. The High Court has simply stated that the purpose of show cause notice is primarily to enable the noticee to meet the grounds on which the action is proposed against him. No doubt, High Court is justified to this extent. However, it is equally important to mention as to what would be the consequence if the noticee does not satisfactorily meet the grounds on which an action is proposed. To put it otherwise, we are of the opinion that in order to fulfill the requirement of principles of natural justice, a show cause notice should meet the following two requirements. That is, number one, the material grounds to be stated, which according to the department necessitates an action. Two, particular penalty action which is proposed to be taken. It is this second requirement which the High Court has failed to omit. We may hasten to add that even if it is not specifically mentioned in the show cause notice, but it can clearly and safely be discerned from the reading thereof, that would be sufficient to meet the requirement. So, my lord, these are the requirements which are the ingredients of a show cause notice. Summary to a show cause notice cannot substitute the show cause notice. And my lord, what Lordship has held, that has also been discussed in the case of Mufadla Industries, my lord. In the first volume, kindly see, my lord. The compilation, my lord. 100.
Page?
Page 100, my lord, that is metal forging, and we are concerned with page, my lord, 105, para 12, bottom para, my lord. What, my lord? Para 12, my lord. Page 105, bottom para 12. It is an admitted fact that a show cause notice, as required in law, has not been issued by the revenue. The first contention of revenue in this regard is that since the necessary information required to be given in the show cause notice was made available to the appellants in the form of various letters and orders, issuance of such demand notice in a specified manner is not required in law. We do not think that we do think that we cannot accede to this argument of the learned counsel for the revenue. Herein, we may also notice that the learned technical member of the tribunal has rightly come to the conclusion that the various documents and orders which were sought to be treated as show cause notices by the appellate authority are inadequate to be treated as show cause notices contemplated under Rule 10 of the rules or Section 11A of the Act. My lord, I'll pause for a while. Section 11A and Section 73 are parametric provisions. Section 11A of the Central Excise Act and 73 of the GST Act, or I would say CGST Act, are parametria. Even the judicial member in his order has taken almost a similar view by holding that letters, either in the form of a suggestion or advice or deemed notice issued prior to finalization of the classification, cannot be taken note of as show cause notices for the recovery of demand. And we are in agreement with the said finding of the two members of the tribunal. This is because of the fact that issuance of so cause notice in a particular format is a mandatory requirement of law. My lord, I will again pause for a while. Particular format, when we say, then question may come to mind, what format? Where is that format? The format we can discern from the judgment of Supreme Court in the case of Gorkha Security and Oryx Fisheries. The law requires the said notice to be issued under a specific provision of law and not as a correspondence or part of an order. The said notice must also indicate the amount demanded and call upon the HSE to show cause if he has any objection to such demand. The said notice also will have to be served on the HSE within the said period, which is either 6 months or 5 years as the facts demand. Therefore, it will be futile to contend that each and every communication or order could be construed as a so cause notice. For this reason, the above argument of the revenue must fail. So my submission is, my lord, this summary to so cause notice cannot be substituted as a so cause notice. And in that support, I have read this judgment, my lord. And my lord, my last submission would be in respect of section 75, so section 3, which your lordship also indicated in the last order.
75(7).
I am sorry, my lord, your lordship is right. Subsection 7.
Yes.
Section 75 deals with general provisions relating to determination of tax. Page 18 of the compilation, my lord. Page 18 of the compilation.
Of which compilation?
The same compilation, my lord, in which we are just reading judgment of metal forging.
Yes.
18, 1-8, I am saying 1-8, my lord.
Oh, 1. Yes.
Section 75. General provision relating to determination of tax. So this is the general principle which deals about, which talks about the way section 73 and 74 provisions can be implemented. So there are several guidelines here. And then, my lord, section 75, section 7. The amount of tax, interest and penalty demanded in the order shall not be in excess of the amount specified in the notice. Notice means the show cause notice of 73(1) and 74(1), and no demand shall be confirmed on the ground other than the ground specified in the notice. So, my lord, what is not in the notice or show cause notice 73(1), 74(1) cannot be ground to confirm the demand. There may be several things in the summary, but not in the notice. On that ground, no demand can be confirmed. My lord, in the same compilation, kindly see page 228. 228, my lord. My lord, judgment of Supreme Court in the case of Commissioner of Central Excise versus Seatal International. Kindly see, my lord, page 236. Page 236, last page, my lord. Para 19.
Yes.
My lord, in fact, in the service tax and excise regime, provision like 75(7) was not there. But the Supreme Court, in several judgment, held that you cannot take a ground which is not part of the so cause notice, because so cause notice is the foundation of the case. What is not there in the so cause notice cannot be, demand cannot be confirmed on that ground. And that judgment of Supreme Court has found mention in the section 75(7) now. So we can understand what section 75(7) says from judgment Supreme Court. Para 19, my lord, page 236. As regards the process of rectifying polish, now pressed into service by the revenue, it is trite law that unless the foundation of the case is laid in the show cause notice, the revenue cannot be permitted to build up a new case against SSE. Then judgment of Supreme Court in Toy Engineering, Balarpur Industries and Chamdani Industries relied. Admittedly, in the instant case, no such objection was raised by the adjudicating authority in the show cause notice dated so and so relating to estimate year so and so. However, in the show cause notice dated so and so, The process of electrifying police finds a brief mention. Therefore, in the light of settled legal position, the plea of the learned counsel for the revenue in that behalf cannot be entertained, as the revenue cannot be allowed to raise a fresh plea which has not been raised in the show cause notice, nor can it be allowed to take contradictory stands in relation to the same SSE. So my submission is, my lord, if this show cause notice sustains, then any confirmation of demand will be against the revenue. I will simply taking a plea that there is no ground raised in the show cause notice. So any vague show cause notice does not serve the purpose of revenue also.
Yes.
That's all, my lord. My lord, the particular line of para in the Bharti Airtel, may I read your lordship to refresh your lordship memory?
Yes.
My lord, in Bharti Airtel, before I read that, my lord, let me read one para from the counter, what they say in the counter, then I will take your lordship to that. In the counter affidavit, my lord, on page 13, in page 13, para 23, they say,
Yes.
page 13 in counter affidavit, para 23, they say, I'm just reading out, my lord. Please don't take trouble to turn the pages. That with regard to statement made in para 4 of the petition, it is stated that point 127 has raised certain questions to which the department wishes to state the following. It is humbly stated that the show cause notice is issued by the proper officer through the online portal of GSTN, and hence a format is common for the same. And since the GST Act envisaged to digitalize the entire process, hence there is the provision of issuance of show cause notice and its summary online, my lord. That is a mistake. Online by means of DRC01 through the online GSM portal. Since the system is designed in a way that the show cause notice is built on a standard format, it is the summary thereof where the proper officer can make his comment. And in this case, the proper officer has indeed followed due procedure by mentioning the violation and charges on the petitioner and the means by which the petitioner has resorted to tax evasion. So, the understanding of department is that under 73(1) also there has to be a format. And department says that it is a prefixed format in the GST portal. That is why we are helpless. We cannot alter it. In all and sundry and thousand so cause notice will be all similar worded. So it is not a so cause note at all. What Supreme Court said, what is the role of GST portal? If we can show that from the statute also, but since judgment has come, so I am reading from judgment, my lord. In the case of Bharti Airtel para 33, page 273, my lord.
Yes.
Para 33, page 273, last two lines I am reading. The common portal. The common portal is only a facilitator to feed or retrieve such information and need not be the primary source of doing self-assessment. The primary source is the form of agreement, invoice, challans, receipts of the goods and services, and books of accounts, which are maintained by the SSC manually electronically. These are not within the control of the tax authorities. This was the arrangement even in the pre-GST regime. Whilst discharging the obligation under the concerned legislations, the position is no different in the post-GST regime, both in the matter of doing self-assessment and regarding dealing with eligibility of input tax credit and output tax liability. Indeed, that self-assessment and declaration would be anyway subject to verification by the tax authorities. The role of tax authorities would come at the time of verification of the declaration and return submitted filed by the registered person. So my humble submission is that the way section 11A have been read, the way section 73 of the service tax have been read, in the same manner the section 73, 74 of this JGST and CGST Act have to be read. And there is no change in the pre-regime and post-GST regime. The tax administration remains the same. What was there prior to GST, that continues after GST. And the role of GST portal is not that of a quasi-judicial authority. The quasi authority under 73, 74 cannot abdicate its functions to the portal. Quasi-judicial function requires due application of mind. It cannot be dedicated to a computer system or a computer system which is having no biological mind. It requires application of biological mind and facts of each case. So that not be delegated to the computer system, and SOCA's notice under 73(1), 74(1). In fact, the statute has also not said that it will be in a fixed format, as it has said about the DRC 01 in 142(1) small a.
Right. Mr. Pati,
Yes, my lord.
Any argument in defense?
My lord, it was argued on the last occasion, but your lordship had disclosed the mind that the summary of show cause is not complete, and it ought to be with a show cause notice, detailed show cause notice. So after hearing us, my lordship has indicated the entire order on the last occasion, and these points were everything was argued before your lordship. And similarly, my lord, in WPT 2444 of 2021, your lordship have already quashed the show cause notice on similar line. That was a summary show cause in that case. In the case of this petitioner itself, the difference being that it was under section 74. That I was pointing out at the very inception only.
Very well. So if we quash the notice this time again, again the department issues a notice in the similar format, do you again expect us to quash it? Or
my lord, both the writ petitions were preferred simultaneously, my lord. Perhaps I'm not clear. Two show cause notices, one under 73, under 174. It is not that after your lordship has quashed on the earlier occasion, we have again committed this mistake. My lord, I have advised the officers, my lord, in some district I have also spoken to them. This is happening in few districts only. Most of the districts, they are issuing the show cause notice also with the summary. And my lord, we will also do one thing. We'll also circulate both the orders passed by your lordship to all the assessing officers, so they are aware that yes, a detailed show cause notice is to accompany with the summary of show cause. So we'll also inform them in writing. So this will not happen in future. Because one thing, my lord, section 75(7), if the show cause notice, I am also conscious about that fact, that will ultimately go against us in future if there is no detailed show cause notice and the order is passed. It will be very difficult to sustain that order.
लिखिए। impugn notices, the impugn show cause notice dated 14 June 2021, नहीं ऐसे लिखिए, the present challenge relates to the show cause notice dated 14 June 2021, Annexure 1, issued under Section 73 of the Jharkhand Goods and Service Tax Act 2017 within bracket or short JGST Act 2017 bracket close, and the summary of show cause notice in form DRC 01 dated 14 June 2021, Annexure 2, also issued by respondent number 3 under Rule 142(1) within bracket small a of the JGST Rules 2017. Since the previous show cause notice dated 7 June 21, Annexure 3, issued under Section 73 of the JGST Act has been withdrawn. Stop. The impugn show cause notices are extracted here under Annexure 1, page 97, Annexure 2, page 100. Stop. Learned counsel for the petitioner, Mr. Kartik Kurmi, has inter alia made the following submissions in support of the challenge. ये लास्ट पेज का जो ऑर्डर है ना, इसका ये से लेकर के यहाँ तक stop. He has placed reliance upon the decisions of the apex court
Mafatlal Industries.
Yes, sir. Come. He has relied upon what constitutes a proper show cause notice has been elucidated in the case of so and so 2014 9 SCC 105 para 2122. Stop. Mr. Kurmi has relied upon the case of so and so 2003 2 SCC page 36, where at para 12 the apex court has explained the ingredients of a proper show cause notice. Stop. Further, reliance has been placed on so and so 2011 1 SCC 109, in particular para 19, in a case under section 11A of the Central Excise Act 1944, where the apex court has observed that unless that it is trite law that unless the foundation of the case is laid in the show cause notice, comma, the revenue cannot be permitted to build up a new case against the SSC. Stop. Section 11A is in of the CEA is in pari materia to Section 73 of the JGST Act, under which the impugn notice has been issued. Stop. In order to further explain, in order to answer the defense taken by the respondents in their counter affidavit, specifically at para 23, then counsel for the petitioner has relied upon the judgment of the apex court in the case of Union of India versus Bharti Airtel Limited, 2021-54 within bracket GSTN 257 SC para 23. So it is submitted that the apex court has observed that the common portal under the GSTN is only a facilitator to feed or retrieve such information, and the basic concepts of a proper show cause notice cannot be done away with by the respondents by simply saying that the JGST rule provides a prescribed online format under DRC 01 in which only the summary of the show cause notice can be issued. The respondent authorities are under a mistaken belief that the ingredients of a proper show cause notice is replaced by a summary of show cause notice under DRC 01. Stop. Then counsel for the petitioner has profusely relied upon a decision rendered by this court in WPT number 2444 of 21, dated 6th October 21, in the case of the same petitioner on a similar challenge relating to a show cause notice issued under Section 74 of the JGST Act 2017. He has referred to the opinion of this court at para 14, 15 and 17 of the judgment in particular. Stop. He has has summarized his arguments to the effect that if the show cause notice is vague, not only does the petitioner denied proper opportunity of defending himself, but such a proceeding could end up in vague results and would also not be in the interest of the revenue stock. Moreover, no imposition of tax, interest and penalty, no amount of tax, interest or penalty can be imposed on grounds which are not specified in the notice as per section 75(7) of the JGST Act. Stop. The notice lacking in the proper ingredients of a show cause notice. The impugn notice at annexure 1 is lacking in the ingredients of a proper show cause notice and therefore deserves to be quashed. Stop. Mr. P.S. Pati, Learned Counsel for the State, has taken a plea that has filed a counter affidavit and taken and defended the impugn notices. According to him, the show cause notice and a summary of the show cause notice have been issued in accordance with the JGST Act 2017 and its rules. Referring to the summary of the show cause notice at annexure 2, he submits that it clearly mentions that the petitioner has received payment which it has not disclosed in its return and hence evaded the payment of due tax to the government. The summary of the show cause notice has elaborately stated the violations of the petitioner and is in consonance with section 73 of the Act. The petitioner cannot be allowed to club the period of April 2020 to October 2020 to justify its action. The various returns/abstracts/certificates such as GSTR 3B, GSTR 7 and GSTR 7A have been framed to ensure that the liabilities are properly discharged. Then counsel for the petitioner, respondent has further relied upon the statements made at para 23 of the counter affidavit and submitted that the show cause notice issued by the proper officer through the online portal of GSTN is in the prescribed format. And the system is designed in a way, format TRC01. The system is designed in a way that the show cause notice is built on a standard format and the summary thereof. And in the summary thereof, the proper officer can make his comments. The officer has followed the due procedure by mentioning the violations and charges on the petitioner, by which he has resorted to tax evasion. Stop. He further contends that Form GST ASMT 10 under Section 61 of the JGST Act, read with Rule 99 of the JGST rules, does not appear to be a condition precedent for raising and acquiring jurisdiction under Section 73 by the proper officer. Stop. Then counsel for the respondent submits that the decision rendered by this court in WPT number 2444 of 21 was in respect of a show cause notice issued under Section 74 of the JGST Act, where it has been held that the ingredients of fraud
by reason of fraud or any willful misstatement or suppression of fact to evade tax.
fraud or
My lord, in the judgment, your lordship. Your lordship judgment.
Page 7, paragraph 13, last line, my lord, it has been quoted by your lordship.
Where the ITC wrongfully, where the allegations relating to fraud or any willful misstatement or suppression of facts to evade tax are required to be specifically alleged in the show cause notice. The present notice is under Section 73 of the JGST Act, which doesn't, under which no allegations of fraud, misrepresentation, or suppression of facts, etc., are required to be pleaded. Stop.
जयंत का फोन था.
We have considered the submission of learned counsel for the parties. Stop. A perusal of the impugned show cause notice at Annexure 1 clearly creates a clear impression that it is a notice issued in a format without even striking out any irrelevant portions and without stating the contraventions committed by the petitioner. Stop. The summary of the show cause notice under DRC 01 indicates that as per the statistics received from the headquarters/government treasury, it has come to the notice of the department that the petitioner had received a sum as payment from the government treasury against works contract services completed/partly completed during the above mentioned period, April 2020 to March 2021, whereas the liability reflected by him through file returns is less than the above mentioned sum, as per GSTR 3B. Stop. As such, he was not reflecting the total payment received and consequent total liability accrued in the file returns, just to evade payment of tax, due tax to the government. It needs to be mentioned here that even the summary of the show cause notice does not disclose the information as has received from the headquarters/government treasury as to against which works contract service completed or partly completed, the petitioner has not disclosed its liability in the returns filed by it under GSTR 3B. We have held in the case of this same petitioner in WPT 2444 of 21 in a challenge to a show cause notice under section 74 of the JGST Act that a summary of show cause notice as issued in form GST DRC 01 in terms of Rule 142 within bracket 1 of the JGST Rules 2017 within bracket Annexure 2 impugned herein cannot substitute the requirement of a proper show cause notice. Stop. Then it would be profitable to reproduce the opinion of this court in the case of the same petitioner on the general principles governing the issuance of a proper show cause notice. This court para 14, 15 and 17 of the judgment is quoted here and below. Stop. The apex court in the case of Gorkha Securities concerning an order of blacklisting has laid down the ingredients of a proper show cause notice at para 21 and 22 of the report, which are extracted here and below. Stop. The rationale, as held therein, the requirements of principles of natural justice can only be met if a show cause notice contains the material/grounds which according to the department necessitates an action, semicolon, and 2, the particular penalty/action which is proposed to be taken. Stop. Even if it is not specifically mentioned in the show cause notice, but it can be clearly and safely discerned from the reading thereof, that would be sufficient to meet this requirement. Stop. We are afraid that on the one hand, the show cause notice is completely silent on the violations or contraventions alleged to have been done by the petitioner, regarding which he has to defend himself. The summary of show cause notice at Annexure 2, though cannot be a substitute for the show cause notice, also fails to prescribe the necessary facts which could give an inkling as to the contravention done by the petitioner. As noted here in above, the brief facts of the case do not disclose as to which works contract services were completed or partly completed by the petitioner, and regarding which he had not reflected his liability through the filed return as per GSTR 3B for the period in question. Stop. The summary of show cause notice cannot be a substitute for the show cause notice as has been held by this court. Now, it needs no reiteration that a summary of show cause notice in form DRC 01 could not substitute the requirement of a proper show cause notice. At the same time, if a show cause notice doesn't specify the grounds for proceeding against a person, no amount of tax, interest or penalty can be imposed in excess of the amount specified on the notice or on grounds other than the grounds specified in the notice as per section 75(7). Stop. Learned counsel for the petitioner has, relying upon the case of Bharti Airtel Limited, Supra, contended that the apex court has observed that the common portal of GSTL is only a facilitator the format GST DRC 01 or 01A are prescribed format on the online portal to follow up the proceedings being undertaken against an SSC. They themselves cannot substitute the ingredient of a proper show cause notice. Stop. if the show cause notice doesn't specify a ground, the revenue cannot be allowed to raise a fresh plea at the time of adjudication, as has been held by the apex court in a matter arising under Central Excise Act in the case of Sheetal International, Supra, as at para 19 quoted here and extracted here in below. In a notice under section 74 of the JGST Act, the necessary ingredients relating to fraud or willful misstatement or suppression of facts to evade tax have to be included. Whereas, in a notice under section 73 of the JGST, of the same Act, the revenue has to specifically allege the violations or contraventions which has led to tax not being paid or short paid or erroneously refunded or input tax credit wrongly availed or utilized. Stop. It is strike law that unless the foundation of the case is laid down in the show cause notice, the assessee would be precluded from defending the charges in a vague show cause notice. That would entail violation of principles of natural justice, as he would be denied an opportunity to establish his innocence. Stop. He can only do so if he is told as to what the charges level against him are and the allegations on which such charges are based. Reference: reliance is placed on the opinion of the Constitution Bench of the Apex Court in the case of Khemchand, which has been also relied upon in the case of Oryx Fisheries Private Limited, Supra, and profitably quoted in our decision rendered in the case of the same petitioner in WPT number 2444 of 21. Stop. We are thus of the considered view that the impugned show cause notice as contained in Annexure 1 does not fulfill the ingredients of a proper show cause notice and thus amounts to violation of principles of natural justice. Stop. The challenge is entertainable in exercise of writ jurisdiction of this court as on the specified grounds as clearly held by the decisions of the apex court in the case of so and so. Mr. Kurmi, have you enclosed any judgment in your compilation on the question of maintainability of the writ petition?
My lord, my lord, my lord. In fact, my lord, if your lordship would kindly see the gist, judgment was separately sent, my lord. The gist, if your lordship would see, Magat Sugar,
Just okay, yes.
Magat Sugar, my lord. Next page, kindly see.
SCC online Supreme Court 801, para 24 to 24 and 25.
My lord, 28, yes, 24, 25, my lord. My lord, 28, next, kindly see, my lord, next page. I think it is quoted. 28 is quoted.
28, yes, 24, 25, 28 is of another decision.
Yes, quoted in 25.
Quoted in 25.
My lord.
So, accordingly, the impugned notice at Annexure 1 and the summary of show cause notice at Annexure 2 inform GST DRC 01 are quashed. Stop. This court, however, is not inclined to be drawn into the issue whether the requirement of issuance of Form GST ASMT 10 is a condition precedent for invocation of Section 73 or 74 of the JGST Act for the purposes of deciding the instant case. Stop. Since the court has not gone into the merits of the challenge, respondents are at liberty to initiate fresh proceedings from the same stage in accordance with law within a period of 4 weeks from today.
My lord, the last issue, ASMT 10, my lord, that issue may be kept open.
Well, that is already decided by your lordship in the previous day. Your lordship has specifically held in WPT 2444 that it is not required.
We are leaving it open. We are not getting.
Yes, that's correct. That's correct. Just if your lordship can kindly indicate. My friend has read it otherwise. My friend says that is closed. So
No. We have not commented on the precondition of ASMT.
just 1-2 words may be added, my lord. The issue is kept open. If your lordship so feel.
No, it's clearly said when we have not gone into that issue is not decided.
My lord.
The writ petition is allowed in the manner and to the extent indicated here and above.
Deeply obliged, my lord.
Obliged, my lord.
Grateful, lords.
WPT number 291 of 2021, Mr. Vijay for
No, item 19, my lord.
No, there are 2-3 matters which get over. Just 23, there is a request for adjournment.
Yes, Your Lordship. I have filed that request for adjournment, Your Lordship, on behalf of the respondent number 3 and 4, Your Lordship. Lordship, am I audible?
Yes.
Yes, Lordship. Lordship, on behalf of respondent number 3 and 4, Your Lordship, I have sought time, Your Lordship. Lordship, actually, what has happened, my client was actually infected with COVID, Your Lordship, in this last month itself, Your Lordship. So we were unable to have a conference in this matter, Your Lordship.
Otherwise, for the petitioner, Mr. Indrajit Sinha, what is this?
Milord, I am appearing on his behalf, Milords. Mr. Sinha's behalf, Milords.
So, your preparations are ready?
Milords, we were awaiting the counter of private respondents. The state has already filed a counter in this matter, Milords.
So, Mr. Gautam, you were granted time on 29th November 21.
Yes, Your Lordship. Yes, Your Lordship.
10th January also on the grounds of COVID. So, it is now at your behest that lingering.
Lordship, as a matter of last indulgence, if 2 weeks' time may be granted to me, Your Lordship.
On the same ground of recovery from COVID, a prayer for adjournment has been made by Learned Counsel for respondent number 3 and 4 for filing counter affidavit. Stop. By way of last indulgence, for the email to that effect was also circulated yesterday. By way of last indulgence, 2 weeks more time is allowed to the respondent number 3 and 4 to file their counter affidavit. Matter will be listed after 2 weeks.
Obliged, Your Lordship.
I pay for the state, my lord.
Mr. Salona Mittal, AC to GA1 for the state. For petitioner, Mr. Kumar Vaibhav.
Item 24, WPT number 5376 of 2021, Mr. Nitin Kumar Prasad for the police matter. Mr. Rahul Ahmad on the
This matter, there is a batch which has been filed, and I have passed on the list to the learned courtmaster. Since it was late night, I could file the judgments, I could mail it. My paper books are ready. If it can come on Tuesday, I'll furnish it by tomorrow. The paper books, because now the issue has been decided by almost all the courts,
This other batch of writ petitions, at what stage are they pending?
It's also fresh filing, and I have given the list, I have given the list.
Maloj, in all these matters, there are factual allegations, Maloj, for which I'll have to file a counter affidavit, Maloj.
All the matters be first listed together, and if necessary, then you take time to file response.
Much obliged.
Then counsel for the petitioner, Mr. Nitin Kumar Pasari, submits that same issues are involved in a number of writ petitions, such as WPT number so and so. Stop. Those cases may also be listed together. Stop. As such, the matter is adjourned to next Wednesday.
Yes.
Let WPT number so and so. Let the aforesaid petition be also listed along with this. Rahul Ahmad for the department.
In the meantime, I'll file the paper book,
File it, but response is necessary. Let them come.
Yes.
WPT number 125 of 2022. Mr. Nitin Kumar Prasad for the police and Mr. Kumar Yadav of the respondent.
In this matter, I have taken instructions from my client. The prayers, so far as serial number, prayer number C is concerned, C and D is, the registration has been revoked. There is Nothing now, so far as registration is concerned. So far, the issue of blocking of input tax credit is concerned. I have already filed my reply before the authority concerned. They may decide the issue this way or that way. So I will
Yes,
not be pressing that prayer, Manoj.
yes, Manoj. It can be done.
So there are two parts, one relating to blocking of ITC and the other relating to
Suspension of registration.
suspension of registration. One
Yes, Manoj.
relief has already been granted.
Yes, Manoj. Yes, Manoj.
And for second, you want to pursue your representation before the
Absolutely, absolutely, Manoj. Absolutely.
So we can dispose it off.
Yes, 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 Manoj.
Third learned counsel for the parties, Mr. Nitin Kumar Prasadi for petitioner, Mr. Saruna Mittal ACT GA1 for respondent. The petition has been prepared for the following reliefs. Para 1 को quote कर दीजिए. ABC. Stop. Para. Learned counsel for the petitioner submits on instructions that the
Manoj, the suspension of registration has been revoked.
Yes.
That the suspension of registration of the petitioner has been revoked during pendency of the writ petition.
Yes, Manoj.
Stop. This only surviving grievance relates to blocking of the ITC lying in the electronic credit ledger of the petitioner.
Yes, Manoj.
Petitioner has already responded to the show cause notice.
Show cause notice has not yet been issued, Miloj. It is only the ASMT 10 has been issued, and pursuant thereto, we have submitted the documents. Show cause notice is still awaited.
Petitioner has responded to the notice in Form GST ASMT 10 issued under Section 61 read with of the JGST Act 2017 read with Rule 99(1) of the JGST rules.
Yes, Manoj.
Stop. Petitioner has also made representation before whom?
Minutes before the authority, respondent number 3.
Before the respondent number 3 against the blocking of for lifting for revocation of the blocking of the ITC lying in the electronic credit ledger. Stop. Petitioner seeks permission to withdraw the writ petition to pursue his representation before the authority concerned. You
It's
need
only
any
it's only one line. The withdrawal shall not be taken otherwise by the authority concerned.
He submits that the withdrawal of the writ petition may not be construed as waiving its grounds of challenge.
Yes, 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 Manoj.
Waiving the grounds available to it in law and on facts.
Yes, Manoj.
For the respondent number 3. Stop. It goes without saying. Learned counsel for the respondent, Mr. Mittal, submits that it is up to the petitioner to pursue his representation before the respondent number 3, which shall be considered in accordance with law. Stop. In view of the submissions made by learned counsel for the petitioner, the petition is dismissed as withdrawn, leaving it to the petitioner to pursue his representation before the respondent authority relating to his grievance of blocking of ITC in lying in the electronic credit ledger.
Much obliged.
So now item 19 to 21, what is the situation? Who appears for the state?
I am appearing, Lord, along with Mr. Sokwan Yadav and.
Very well. All these 3 petitions relate to the same petitioner and raise the same issues.
Same issues, my lord. In fact, the first petition, that is, my lord, 1261 of 2020, in that petition, 3 periods were clubbed. 2017-18, 18-19, 19-20. So your lordship directed to file separate petition for each year. So thereafter, my lord, the first period was confined in the first writ petition. For other two period, my lord, I filed two separate writ petitions. Issue is one and same.
You perhaps this matter was earlier argued by you,
my lord,
before the previous bench,
my lord.
and then on the last date, in order to submit revised written notes, etc., it was adjourned for 31st.
It is already filed. It is to my knowledge, my lord. It is already filed. Kindly check your lordship. 3 revised written notes were already filed.
Very well. So I mean to say that you need to argue afresh because the bench
My lord,
is.
my lord, my lord, my lord, my lord.
So in that case, if all the councils are ready, we can take it up after lunch. State councils?
Milord, today, the council of the petition will argue, Milord, we will reply. Or some other date, as your lordship, Milord, we should take it.
तो वॉल्यूम किस लोग और निकलो तो कहाँ देखो किस लोग वॉल्यूम एक और देखो वो फाइल चला गया थर्ड वॉल्यूम देखो
Mr. Puri,
my lord,
what expected time will you take?
My lord, at least I will take 2 hours.
So in that case, today it will spill over for another day.
My lord.
And tomorrow our bench will not be there because I am going out. We would have liked to hear it in continuity so that both the sides conclude on, if not on one day, then the next day.
My lord.
That will be better, Milord.
In that case, we can keep it on next Wednesday. Wednesday, we don't have much fixed matters. आज ही का एक हुआ है ना? हाँ, मंगल को भी मंगल को एक हुआ। हाँ। ये आइडिया है मंडे वाला किस चीज का है कब एग्जाम Mr. Pasari, on Monday,
yes,
is there any matter Prabha Energy of your office?
Yes, Milot.
What was that about?
Milot, it was about a mismatch which was alleged, and thereafter, when we filed the rectification, that has not been acted upon. So, my lord said that the instruction has to be taken by the state that what they intend to do with the rectification application, because that has been kept pending and my ITC has been blocked.
So that is not a longish matter on Monday.
No. That should not take more than 15-20 minutes, Milot.
Tuesday. We keep it on Tuesday.
My lord, that suits me also, my lord. On Monday, I had some preoccupation, lordship. Tuesday,
Tuesday we keep it on Tuesday so that if it spills over, hopefully Tuesday will have enough time. But in case it spills over, we can continue on Wednesday.
my lord, next week it will be virtual or I will have to travel, my lord.
We are not aware of any such decision as of now. I don't know. Nothing that sort, but can't make a guess also. Whatever it is, suddenly, I don't know, Supreme Court has opened up 2+, not on miscellaneous days.
2 days, 2 days will not physical.
Yes. So let us keep it on Tuesday.
नहीं मंडे शाम को निकलना है. ट्रेन नहीं है. Manos, I think on Monday there is no train in the second half from here. देखो टिस देख लेगा.
No, why do you anticipate something which is a very contingent?
No, my lord, ultimately, if it is going to be physical, then my lord, that I was looking for.
Then we'll accommodate you.
My lord, let it be 15th, my lord.
Let it be on Tuesday, 15th. So, as prayed for by Land Council for the parties, let the matters be listed on 15th February 2020. Send your appearances.
Deeply obliged, my lord. Deeply obliged.
Thank you.